right, guys. Hey, come on in. Come on in. Class is starting. Happy Thursday. Happy Thursday. Happy Thursday. Come on in. Let's get started. Let's get started. Welcome to another session of Title Experts University College of Closed and Funded. I am so happy to see all you guys coming in and getting started to have this very timely conversation about escrow disputes. Escrow disputes. Nobody likes to have this conversation, but it happens. It happens. So we have to go ahead and have a conversation about what happens when an escrow dispute comes up in our transaction. Listen, I'm excited. I hope you guys are excited about a long weekend coming up. Well, you still get to take a break. You need a t-shirt? I know. Shoot me an email with your size. I will send you. I love this shirt. I wear them probably a couple times a week. But shoot me a message with your address and your size, and I will send you a closed and funded t-shirt. Listen, with that being said, let's go ahead and get started. So happy to see everyone. We will not delay. So, today's conversation, I had to bring it back. This again, we're talking about escrow disputes. Show me the money. Show me the money. When you guys, you're excited, you think you're going to closing, and then all of a sudden, I got you. All of a sudden, we got, things fall out, things happen. So I want you to be aware before we get to that place as to how you resolve a potential escrow dispute. So before we get started, I want you guys to know why I'm passionate about Title Experts University. I want you guys to know why I'm passionate about this and why I am always ready, willing, and able to have a conversation to bring to the real estate professionals fundamentals. Because I know that education and information is empowering. I know that if you are informed, if you have information, that you'll go further. And so one thing I always say is when you encounter an issue that impedes your forward progress, you feel like, oh, I can't go forward. I need to, this deal is dead. It's generally just because you've reached the extent of your knowledge. You don't realize that there's a resolution, that there's something you can do to work around or get ahead of that issue. So that is the mission and the goal of Title Experts University. Because when you learn more, you earn more. Guys, that's that, like, literally, if you take nothing else with you today, in addition to everything else, I want you to gain the mindset that you learn more to earn more. You learn more to earn more. The more skill sets you have, the more information that you gather, it opens up opportunities for you. So you want to always be prepared to learn. And so again, that is the basis, that is the mantra, that is the genesis, the whole reason why Title Experts is here, is to give the realtor partners an opportunity to learn more so that they can earn more. Now, with that being said, a little bit about myself. I've learned a little bit. For those who I have not had an opportunity to meet before, this is what I've learned in the 21 years that I've been around. I am a proud University of Florida graduate. Go Gators. Earned my Juris Doctorate, my law degree from Santa Clara University in Santa Clara, California, where I was the founder of the Real Estate Law Society. Came back home. I am a Florida girl to the University of Miami. I got my LLM in real property development. And I am a licensed Florida real estate sales professional. I got my first license in California while I was in law school. Came back home and got my license here in Florida. And so, honestly, guys, you guys know that I operate multiple different real estate service companies between the law firm, the title company, brokerage, and now mortgage. Is all by virtue of the fact that I have always put myself in a place to learn. And so this space that we curate every week is to give you all an opportunity to learn. This is, let's take one second. We are This conversation each week is powered by Title Xperts. Title Xperts, as you know, is our title company. We are attorney owned and operated. We close all of Florida. We welcome you the opportunity to have a Title Experts closing experience. Some of the features and benefits of working with us, again, we are attorney managed. We do provide a dedicated closing team, regular status update, helpful closing guides, including training. You guys hear that? It's about to rain. And rush processing is available. So if you haven't had an opportunity to work with Title Experts before, feel free to give us a call. Our new contracts are sent to contracts@titleexperts.com. General closing questions are sent to closings@titleexperts.com, and our vanity number is 866-5-Experts. That's how you can work with us. We look forward to seeing you at our closing table. Now let's get into today's discussion. Escrow disputes. Escrow disputes. I promise you, I never like to hear about a deal failing. And I certainly do not like to hear about a deal failing, which puts a buyer's escrow at risk. It is the worst part of what we do, honestly. But you do understand that that is the basis of our conversation today. When a real estate transaction fails at the fault of the buyer, generally the seller will seek to retain the escrow deposit. Again, and we're talking about today from the perspective of a buyer default. If a buyer defaults, the seller is generally going to seek to retain the buyer's escrow deposit. Now, one of the first fundamentals to know is that when there is a dispute over who retains the escrow deposit, the real estate contract itself controls the manner to resolve it. Within your contract itself is how an escrow dispute is resolved. The purpose of today's conversation is to understand, number one, that there is a process. There is a process. How often, I can't tell you how many times there's a dispute and the seller's realtor is like shoots off an email or makes a phone call. Well, we'll just keep their deposit. We'll just make sure that their deposit is sent to, 123 Main Street, or here's my wire instructions. Well, listen, it doesn't work like that. You got to know that it doesn't work like that. The escrow agent will not disperse funds without a fully executed release and cancellation. And what does fully executed mean? Means that it's signed by the buyer and the seller. So even if the listing agent prepares it, your seller signs it and sends it to the selling agent, the buyer's agent, the buyer doesn't sign it, guess what? You got a dispute because they don't agree. They do not agree to release their escrow deposit to the seller and cancel the contract. They do not agree. So this is where the dispute comes in. This is where the disagreement comes in. But the escrow agent cannot unilaterally decide to just release the funds because it could just be black and white. Buyers should have had their loan approval by June 30th, or let's say even June 25th. It's now June 30th. We can't close. There's no loan approval. It could be clear as day. Without a fully executed release and cancellation, the escrow agent will not disperse funds. So that's the first fundamental to know, right? The FAR bar as is contract is the most commonly used contract. That is what's most commonly used. 99% of the time, that's what's used. And so because of that, we have here on the screen the FAR bar as is contract. And I'm going to read from it verbatim so you guys can see this. So it's paragraph 16 of your FAR bar as is contract. Dispute resolution. All right. It says unresolved controversies, claims, and other matters in question between the buyer and seller arising out of or related to the contract, a breach, enforcement, or interpretation will be settled as follows. It's right here, guys, in our contract. Subparagraph 8. Buyer and seller will have 10 days after the date of conflicting demands. What is conflicting demands? Conflicting demands is seller says release it to me, buyer says release it to them. That's a conflict. You guys are not in agreement on where it should go. 10 days after that point, the buyer and seller shall submit such a dispute to mediation under paragraph 6B. So we bump down to paragraph 16B. That gives us further instruction to say buyer and seller shall attempt to settle disputes in an amicable manner through mediation, pursuant to Florida rules of certified and court-appointed mediators, et cetera, Florida statute. Mediator gives credentials of what the mediator must be. And then it says disputes not settled pursuant to paragraph 16, meaning not resolved pursuant to mediation, may be resolved by instituting an action in appropriate court having jurisdiction of the matter. Right? So, know that pursuant to the contract, if you guys can't resolve it at the escrow agent level, the next step is mediation. I know a lot of agents don't know that, because I'm saying, hey, have you started the mediation process yet? Have you started the mediation process yet? No one has done it. No one knows. Now you know. If you can't get an agreement within 10 days, now the escrow agent is saying, hey, you guys need to go pursuant to the contract and go to mediation. Now, as one aside, you know there's a rider that you can execute that says that disputes will be resolved by arbitration. What is arbitration? Arbitration is when a third party will hear both sides. They'll hear the seller's side, their facts and their arguments. They'll hear the buyer's facts and their arguments. And the arbitrator, the third party, will actually make a decision as to who is right. That's not always execute. That rider is generally not executed and attached to the contract. Most of you just proceed pursuant to the contract, which is a mediator, whereas the mediator is a third party. They're going to hear both parties' sides, but they can't make a decision. They're going to give you a suggestion as to, well, if you were to go into a court, if you were to actually file an action, the buyer actually probably would win for these reasons, or the seller actually probably would win. So I suggest, to avoid the cost of litigation, you guys see attorney fees and costs down below in paragraph 17. I suggest that you guys resolve it this way. The mediator is only suggesting the buyer and the seller have to agree, versus arbitration, the arbitrator outright makes a decision just like a judge would. All right. So that's what the paragraph says. That's what the contract says at paragraph 16 about what your resolution process is. Now, the process itself, the way it plays out after there is a conflict with regards to the money, it is different based on the type of escrow agent, right? So we know that your escrow agent can be your broker, or it can be a title company, an attorney, a law firm, etc. And we know that the escrow agent is identified in the escrow agent section of the contract. So if the escrow agent is a broker, the dispute will be resolved pursuant to Florida statute chapter 475.25. You don't need to know that. You need to know what it says. What it says is this: the licensed real estate broker, they're going to resolve the dispute with the assistance of FREC. Everybody knows who FREC is, Florida Real Estate Commission. You know who FREC is, right? So the broker is gonna pull FREC into it and say, hey, you know, I have this buyer and seller. They don't agree about this escrow deposit. I need your help, FREC. What do you say? So it says specifically in that statute, it says if the broker has doubt as to who's entitled to the deposit, or if conflicting demands have been made. Remember, again, we have a release, and I've seen cases where we get a release from the buyer, says issue the funds to them, and then we also get a release from the seller saying release the funds to them, and clearly there's not an agreement. All right. If the escrow agent is a broker, they must promptly notify FREC. They notify FREC, and then they do one of these things. They're going to ask FREC to make a determination of who's entitled to the escrow deposit. And FREC is going to give them an escrow disbursement order. Secondly, they can be submitted to arbitration. Remember, we just talked about the difference between mediation and arbitration, right? Thirdly, what's called an interpleader, that's when a legal action is filed in the court. Before now, we have not gone to court at all. We've kept this outside of the courts. We've dealt with FREC, we've dealt with mediators, we've dealt with arbitrators. But now their third option is to send it to the court, right? And then lastly, like we mentioned before, they can submit it to mediation. So this is what's happening. This is what your client potentially faces when the escrow deposit is held by a broker, right? Now, if the escrow agent is an attorney or a title company, such as Title Xperts, we have a different process. We're going to immediately handle it, treat it as a legal matter. We don't pull freck into it. We immediately go to step number 3, which is send it to the courts. We file what's called an interpleader action. This is why I always encourage realtors to find a resolution. Because if once we file it with the court, whether it's our office or any other office, there's costs associated with it, and those costs are going to be deducted from the escrow funds. So let's say the escrow funds are $5,000. Well, the cost of filing is about $1,200. Now we're talking about $3,800. And you do realize that pursuant to the contract, even after the attorney has placed the funds with the court, you still have to go to mediation first. And each party has to bear the cost of mediation. You have to pay the cost from the mediator. They usually charge about two hours up front, which is $3.50 an hour. They're probably going to want to proceed with an attorney. I don't think you guys are going to try and represent your buyer or seller at mediation. You should not. You should not play an attorney. You don't want those problems, right? And then if it's still not resolved at mediation, they proceed to litigation or arbitration. I don't know about you, but I see time and money. I see time and money. That's not worth it if you just have a conversation. Again, the buyer can be completely wrong. I'm not telling you to say, oh, the buyer was right. It's just, you know what? Under the circumstances, it is not worth us taking time to go to, first of all, have the attorney place the funds with the court, because that's going to knock off $1,200 to $1,500 of the monies immediately. Then we have the cost of mediation, and then we might have the cost of litigation, right? So those are some of the things to communicate to not just yourself, the other realtor, if they don't understand, and your clients. So here's some common defaults that get us in this land of disputes. Number 1, failure to make the second escrow deposit. We talked about this in Contract Hotspots a couple of weeks ago. Sometimes contracts will provide for the buyer to make 2 escrow deposits. One can be, generally they make 1 deposit, but if there's a second escrow deposit and the buyer fails to make the second deposit, that first deposit is at risk to be retained by the seller. I've seen it before. It's not very common, but it is a default, right? Failure to cancel the contract during the inspection period. You guys know that. You know that you should cancel the contract during the inspection period. If that's your only contingency, let's say, for example, it's a cash transaction, and your only contingency for cancellation is the inspection period. You need to cancel before the inspection period ends, or your escrow deposit is at risk. Lastly, failure to make loan application or obtain loan approval. This is where the lion's share of escrow disputes come in. Failure to make the loan application or obtain loan approval. Buyer just didn't get their loan approved, or they failed to make the application. Guys, if you represent the buyer, you should not miss this deadline. So it's so apparent. You shouldn't miss it. All right. So attorney's fees and costs. This is a little bonus. You guys know that in the event that you're not able to resolve the escrow dispute, let's say at the title agent level, you're not able to resolve it at mediation. You're so gung-ho, you go to litigation. You file an action and you take it all the way to court. The prevailing party, the person that wins, is going to be entitled to attorney's fees and costs. What does that mean? That means your buyer is just gung-ho. They will not release this escrow. You're saying, hey, listen, Our deadline to get loan approval was June 25th. It is now July 15th. The seller has extended this so many times. We do not have a leg to stand on to get your $15,000 escrow deposit back. I don't want to make it too ridiculous. We don't have a leg to stand on. It's best for us to negotiate to either get half or just something. And they're just like, no, 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 we're going to court. Well, again, if they take it to court and they litigate it and the seller wins, now the seller is entitled to the balance of the escrow deposit that has not been eaten up by cost, as well as their attorney's fees and cost. So this is another conversation point to make sure that you have with your clients in the event that you're not able to get them to resolve it. And one of the last points is I get this question all the time. Well, if I have an escrow dispute, can my seller then go ahead and place the property on the market? An escrow dispute in and of itself does not prevent the seller from advertising or selling the property, from putting the property back on the market. An escrow dispute in and of itself does not. Now, if the buyer, let's say, for example, files an action in court and records a list pendants against the property, against the seller's property, now we have an issue. Now we have a cloud on title, just like anything else that would come up in a title search that needs to be resolved. So as a general matter, if there's an escrow dispute, the seller can go ahead and proceed, place the property back on the market and sell it and still be having their conversation about the escrow dispute, unless they have a very litigious buyer that decides that they want to file an action against the seller concerning the sale of that property. They put a lien on the property. There is now a cloud on title that must be resolved, and then the seller cannot proceed with selling the property until that is resolved. A lot of legalese, right? But guess what? Now you are fully informed. You're fully informed of how to approach an escrow dispute. Now, the last thing I want to say is, even though you now have all this information on how to resolve an escrow dispute, how it's going to be resolved, whether it's with a broker or whether it's with a title agent or an attorney, you are very clear on where the procedures and the process are in the contract. You are very clear on whether or not the seller can proceed with selling the property. And you know that little nuance about the buyer being able to tie up the property if they record a lien against the property. Even though you understand all that, guys, as a realtor, be certain not to provide legal advice regarding the probable outcome or resolution of an escrow dispute. What does that mean? Again, using our same hypothetical, our buyer has a $15,000 escrow deposit that's now in jeopardy because of a loan approval default. Your conversation, your communication with your buyer is, this is the process. Not, well, you know what? Our loan approval deadline was June 25th. It's now July 15th. You'll probably lose. You don't want to say that. You don't want to say that. You want to say, you let them come up with that determination. You say, well, this is what the contract says. The contract says that we had to have loan approval by June 25th. It is now July 15th. The contract says that if we do not have a loan approval by that date, we're in default. This is what it says about when a party defaults. And then you wait. And then if they get into conversations about litigation, you refer them to an attorney for counsel on what their probable outcome is. But you yourself, you're now comfortable. You understand how the process works. You're able to have a conversation. And more importantly, guys, this should be able to drive you towards a resolution, drive you to a resolution of an escrow dispute, right? We got through that super quick. Any questions? Any questions? Any questions? Clear as mud, as I say. Should be ready now. You get an escrow dispute. As a matter of fact, what I would love for you guys to do is to avoid our plan is to avoid escrow disputes. We know where the pitfalls are. Do not miss a loan approval deadline. Do not blow deadlines. And if you see yourself coming up on a deadline, address it. Get an extension. Talk to the parties that are responsible for meeting the deadline, right? And then in the event that we fall into an escrow dispute, let's figure out how to resolve it. Because again, it's only going to cost your buyer and or your seller money. If it leaves the title agent's hands, if it leaves the title agent's desk, you just start. Now it's time to start counting. Now it's the today's price is not yesterday's price, is not today's price. That cash register is going to start dinging because now it's going to be an expense to your client. So in closing, as we wrap up today's session and go into a pretty good I'm glad you enjoyed, as we go into a 3-day weekend eventually after tomorrow, and as we prepare to shift into really what the second half of the year we are. Many of you have found great success in the first half of the year. We have some lofty goals, right, that we set out at the beginning of the year, and some people are on an upward trajectory, I'm sure, and some may be leveling out, or some may not be pacing where they wanted to pace at this point in the year. But I want to leave you in closing with this thought: what you cannot do, you must do. Whatever you feel like you cannot do, that thing is what you must do. If I were to ask everyone right now, what is the lever? What is the one domino in your business that you know will knock down every other domino and start a momentum of production, a momentum of revenue, a momentum of building your business? Most people know what that thing is. Most people know what that thing is. If not, they have a clue. I want to encourage you today in closing: whatever you cannot do, that thing you must do. You must do. Whatever you cannot do this weekend, develop a plan to just get it done. All right? Because you are more than capable. Guys, that was our session for the day. See you next week. See you next week.